to give us a warm welcome here this morning. Thank you. Dean Bartlett.
Thank you. Busy day, but nothing more important than welcoming you here to Duke Law School. It's wonderful to have you all here. We are, as you can see, particularly those of you who have known us on other trips, in somewhat of a state of maybe not disrepair, but mid-repair. We did a very ambitious renovation project this summer that brought the two classrooms to my left up to grade and also have a new look on the front of the law school. I hope those of you who have seen it previously can appreciate the difference. It's really quite substantial. We are in the process of a 25,000 square foot addition to the law school that you're mostly shielded from, but you could see the big crane and on your way in that's going toward the business school on that side. And then the last piece of this renovation puzzle will be closing in that courtyard where you all just were having coffee. That outdoor courtyard will be, which is really physically the core of the facilities, will be enclosed, and that will be an indoor atrium with various storefronts for career services and student affairs and other such student-centered activities. So we're real excited. I'm sorry that the whole thing isn't done to show off to you, but it's really nice to have some comfortable classrooms and so on. We do have students at Duke Law School. I'm glad to see some of them here. We didn't exactly pick the best date for if we wanted crowds of students. This happens to be the last day of on-campus interviewing. We moved it up several weeks this year, hoping that would result in less interruption of the classroom, and I think it has had that effect. But because we have been doing on-campus interviewing for many weeks now, there are an awful lot of our upper class students are out of town making a long weekend out of their on their off-campus interviewing tours. So some of you wondered if we were a shelf or some other activity. We do have students here. We do educate them. And I'm sorry that with such a great series of panels as are associated with this conference that we don't have a date in which more students could take advantage. Again, thank you for coming. This is one of the many events that the program in public law are sponsoring this year. I think we've had an amazing array of sort of 9/11 related activities this month, and more to come, and I'm real excited about all of the activity that's produced and all of the big name scholars such as yourselves who this has attracted to campus. So thanks for being here. Appreciate your participation in this conference. Take a look around. Anything that you need that you don't have, please be sure to let one of us know. Thank you.
So having plumbed the metes and bounds of the U.S.'s ability to detain people, we're about to discuss what the U.S. can do with them while they are being detained, the metes and bounds of interrogation. I have a very distinguished panel. We're all aware of the torture memos that came out this summer. I worked mightily to find someone I could have come who would be prepared to speak for the content of the torture memos, even in part, and had a very difficult time. So I haven't imposed the burden of defending the U.S. approach as revealed in those memos on anyone on this panel, and in fact, the conversation I think is going to be much broader than those important topics would suggest. We're going to be moderated by Neil Kinkopf, who was the first public law fellow here as the public law program was just getting started and has since gone on to a increasingly distinguished career at Georgia State. Carlos Vazquez from Georgetown Law Center and Scott Silliman from Duke, and our own in-house expert on all of these matters are going to be on the panel. We also had, until yesterday, a fourth panelist, Marty Letterman, who was a longtime OLC line attorney and very knowledgeable on the questions that are going to be raised today. But he's left government. He has another job that sometimes calls on him, and he was scheduled for an emergency oral argument in a matter he's working on in Florida. So he's down in Florida, I assume in a place where the courthouses are still open, today and regrets very much not being here. I'm going to sit in on this panel in his place. I will be unburdened by any recent deep knowledge of the technicalities of the matter, so I will perform the role of outraged citizen from time to time. So.
Our itinerary says, or our agenda, I should say, says that this is a roundtable discussion, and as I look at the table, it's not really round, it's kind of an arc of the circle. And so I'd like to encourage you all to consider the arc in front of you as completing the round table for our discussion. Rather than having presentations and then opening to Q&A, I'd like people to feel free to raise your hand and jump in as we go. And in terms of addressing the subject, I want to begin by kind of laying out a discussion of what the law on point is, and then moving into kind of some of the bigger questions. But I think even on what may, at that level of generality, seem like just a descriptive component of the panel, that is what the law is, the OLC memo demonstrates that, in fact, there is great room for disagreement about what the law is that governs interrogation techniques. So in asking the question that Chris has posed for this panel, that is, now that we got you, what can we do with you? I think there are, in laying out the law, at least two factors that need to be accounted for. The first factor is to ask who, right? Who's asking the questions? And the second factor is where. Where are the questions being posed? And there are three categories of who that we want to take up. First, the category of what rules apply to constrain uniformed military personnel who are engaged in questioning. Second, moving away from that, the question of what happens when the questioning is conducted by military contractors. And then third, what happens when the questioning is conducted by CIA personnel. On the where matrix, the where axis, there are two different questions. First of all, what happens if the questioning occurs, say, in Iraq? And secondly, what happens if the questioning occurs at an undisclosed location? Right. And we can cue the chilling music when I say that. So those are kind of the six different categories in which we want to talk about what the law is and what distinctions we might draw. And so let's start with the first of those, and that is what laws apply in the context of questioning by a uniformed military officer in Iraq. Scott, do you want to start going down that?
Let me address the domestic law on it, Neil. First of all, when we're dealing with a uniformed military member, whether he or she be intelligence or military police or whatever, they are totally governed and under the jurisdiction of the Uniform Code of Military Justice, an act of Congress, 1950, which clearly sets out not only a great deal of protection for those in the military as far as due process, but also a substantial number of punitive articles. So when you're talking about what a military interrogator can do, then the constraint is the Uniform Code of Military Justice under domestic law. And there are certain articles of the Uniform Code of Military Justice which would obviously apply. One is Article 93, which talks about cruelty and maltreatment of one under your charge. And that could be interpreted to mean if you are, in fact, in a position of power under someone who is in your control, then there are certain things you cannot do. And in many ways, that domestic law mirrors the international law constraints on torture, mistreatment, use of force. So you've got a domestic constraint first in Article 93. You also have a very common felony offense of indecent assaults under the Uniform Code of Military Justice, which, if you take even some of the actions that we saw depicted coming out of Abu Ghraib, and I'm not suggesting that those are all justified, but that some of those would clearly constitute offenses under the Uniform Code of Military Justice, and we're seeing that bear fruit in the trials of Lindy England down here in Fort Bragg and other courts-martials that are now ongoing. More significantly, I think you have in the Uniform Code of Military Justice something which is, I think, unique in that it is a violation of federal law, Uniform Code of Military Justice, to violate a regulation or a manual. And if that regulation or manual is promulgated at a high enough level, what we call a general court-martial level, or either a service regulation or one of a major command, then knowledge of that regulation or manual is presumed. And if one violates it, then one can be subject to prosecution under that. Now, I think all of us know, just from what we've read, that the Army has a specific manual that dictates interrogation techniques, and that manual, at least the last iteration I saw, clearly is in consonance with international law, Torture Convention, ICCPR. So if we are dealing with a military interrogator who deviates from that manual in interrogation tactics, wherever it occurs, no matter what the nationality of the victim, as it were, then it constitutes a violation of the Uniform Code of Military Justice.
And how about international law constraints?
Well, I'll defer to Carlos on that because I think he'd like to talk about that. I would suggest, again, the Uniform Code of Military Justice incorporates and is consistent with international law on it. So you have possible prosecution options under principally domestic law, but the standards that apply, obviously, are from both legal regimes.
Yes, as to international law, well, let me start by mentioning a domestic law that implements international law, Section 2340 and 2340A of the Criminal Code, which criminalizes torture performed, among other circumstances, by a U.S. national acting under color of law. It has a definition of torture, which I'm not going to get into now. We'll discuss that later. But it does criminalize torture. It implements the Convention Against Torture, which also has a definition of torture, which is somewhat different, but fairly similar to the one in 2340. So there's a criminal law implementing a treaty which prohibits and requires the criminalization of torture. The Convention Against Torture also prohibits cruel, inhuman, and degrading treatment. Here, the criminal law implementing the Convention Against Torture doesn't include that category. Article 16 of the Convention Against Torture requires parties to prevent cruel, inhuman, and degrading treatment within their jurisdiction. And so if we're talking now about what techniques apply, what limits apply to interrogations in Iraq, arguably Article 16 doesn't apply because it's limited to cruel, inhuman, and degrading treatment within the jurisdiction. I should mention that the International Covenant on Civil and Political Rights also has a prohibition against torture and cruel, inhuman, and degrading treatment, and the relevant article is not limited to treatment that takes place within the state's jurisdiction. It's phrased more broadly: no one shall engage in torture, cruel, inhuman, and degrading treatment. But there's an argument that the convention as a whole applies only to conduct of a state within its jurisdiction, and that argument appears in some of the memos. With respect to the Convention Against Torture, the United States took a reservation to the obligation to prevent cruel, inhuman, and degrading treatment, and the reservation states that we interpret that prohibition to be coextensive with the prohibitions of the 5th, 8th, and 14th Amendments of the U.S. Constitution. In addition, there is the War Crimes Act, which criminalizes, among other things, violations of the Geneva Conventions. I should interject that I became aware after the War Crimes Act was passed that I had a small indirect role in its enactment. The I had an international human rights workshop at Georgetown in which one of the students, who was an older student who had been a prisoner of war in Vietnam, wrote a paper pointing out that there was this gap in U.S. criminal law and arguing that there should be a criminalization of war crimes. I later received a letter from a member of Congress indicating that the War Crimes Act resulted from this paper. And I should interject that from an international human rights perspective, it's sort of a mixed bag in that it imposes the death penalty for war crimes. In any event, the War Crimes Act criminalizes violations of the Geneva Convention, including violations of Common Article 3. There are questions about the applicability of the Geneva Conventions to certain situations, such as the conflict in Afghanistan, the conflict in Iraq, its applicability to Al-Qaeda. The memos take the position that even though the Geneva Convention applies to the Taliban in Afghanistan, but that members of the Taliban are not entitled to its protections because they're not POWs. They also take the position that the Geneva Conventions don't apply to Al-Qaeda at all because Al-Qaeda is not a state. It's not a state signatory to the convention. And then with respect to Common Article 3, which appears in all 4 Geneva Conventions, applies to non-international armed conflicts. And the memos take the position, which the President has endorsed, that Common Article 3 does not apply because does not apply to Afghanistan, and the same conclusion would follow for Iraq, that the Common Article 3 does not apply because it is an international armed conflict, and so it's not a non-international armed conflict to which Common Article 3 would apply. My own view is that it's not so clear that Common Article 3 doesn't apply. I think Common Article 3 was designed to impose a certain minimum threshold of treatment, a minimum threshold of protection to non-international armed conflicts, which traditionally had been completely unregulated by the laws of war. And so one could argue that this minimum threshold applies implicitly to international armed conflicts. And furthermore, there's substantial support for the proposition, including holdings of the International Court of Justice, to the effect that the protections of Common Article 3 are a minimum standard that apply as a matter of customary international law to all, in the context of all armed conflicts. In any event, the War Crimes Act criminalizes violations of the Geneva Conventions in the ways I've suggested, and there are questions about the applicability of the various provisions of the Geneva Conventions. There's, among other possible limits, the constitution of its own force, either of its own force or as incorporated in the Convention Against Torture. Here, there are questions, of course, about what types of treatment are prohibited by the Constitution, and we'll discuss those later. But there are also questions about the extraterritorial applicability of the Constitution. The argument is made in the memos that the Constitution does not provide protection. These provisions of the Constitution don't protect aliens abroad. If that's true, there's also the possibility that the Constitution, as incorporated in the Convention Against Torture through the reservation, does protect aliens abroad, but then again, as I mentioned, Article 16 seems to limit the obligation to prevent cruel, inhuman, and degrading treatment to conduct taking place within the jurisdiction of the state. And then Scott has already spoken about the limits of the Uniform Code of Military Justice, and within the United States, of course, there are just normal criminal statutes that might be applicable. Statutes relating to assault, battery, etc.
Okay. All right, let's cue the chilling music. Suppose we move to an undisclosed location.
Well, first of all, as I mentioned, when you're dealing with what I call the most constraint on interrogation techniques, which under domestic law is the Uniform Code of Military Justice, simply because it punishes violations of the manuals that clearly set out the high standard. The Uniform Code of Military Justice makes no differentiation between where the act has occurred, because the Uniform Code of Military Justice, as envisioned and codified by Congress, extends a criminal jurisdiction, an Article I criminal jurisdiction, wherever an active duty serviceman or servicewoman is, whether it be domestically or outside the United States. Matter of fact, the system was designed to be portable and used in a time of war. Now, interesting, Carlos mentioned the War Crimes Act, which is obviously another domestic statute. And there is a bit of overlap, because the War Crimes Act basically says, and it's Walter Jones's creation right here in North Carolina, that where you have a member of the United States Armed Forces who is either the victim, and that was the principal reason for it, a victim status, or the perpetrator of a violation of, and it lists 4 different categories of international law, principally grave breaches of the Geneva Convention, a series of violations of other statutes, but the one I think which comes into play for our purposes most, Common Article 3 of the Geneva Conventions, that creates federal criminal jurisdiction in our federal courts, not military courts, federal courts. Now, to some extent, if you've got a member of the military, which is our example here involved, there is dual jurisdiction. But what my understanding has always been that the Department of Justice will defer, as they have, to the Department of Defense for trials by military courts-martial when you're dealing with military personnel. So I think what's interesting is that the Uniform Code of Military Justice, which again sets the highest standard as far as what you cannot do in interrogation techniques, is the one that would be the one to govern all military personnel wherever they are interrogating someone, whether it's in Iraq or at your undisclosed location, Neil.
Okay. Carlos, yeah.
Changing the locus of the torture to, or of the treatment, interrogation, to an undisclosed location doesn't have an effect with respect to the Convention Against Torture or the torture statute. To the extent it constitutes torture, both instruments apply when it's perpetrated by a U.S. national. And so even outside the United States, both instruments would continue to apply. Cruel, inhuman, and degrading treatment, as I mentioned, the argument there is that it doesn't apply. It applies, the protection applies only within the jurisdiction of the state, and changing it from Iraq to an undisclosed location outside of Iraq doesn't change the applicability either.
Okay. Citizen Schroeder, have we piqued your outrage?
Absolutely. This is just so annoying to me. I just, no, let me ask a question. Once I had some conversations with Scott about this extensive overlay of military rules and regulations bottomed on the UCMJ and reinforced by manuals and regulations, and the injunction that those must be complied with and knowledge is presumed. Then thinking about the memos that came out of Justice presented me with the following question that I will now put to you, which is, what internal to the military was the operative effect of those memos? Because it seems to me the way you've described military conduct and military legal requirements, although they have some common roots and genesis that they share with the Torture Convention, other international conventions, they are themselves autonomous. They're bottomed on the UCMJ. And all the Justice Department memos purported to be doing, to my understanding, was interpreting the limits under the Constitution, under the U.S. Code, not the UCMJ, and in particular our implementation of the Torture Convention through statutes. So operationally, what happened in the military in terms of its interpretation or application or sense of applicability of those legal analyses that have gotten so much attention?
I think there was the first public acknowledgement, and I stress public, of the tremendous amount of friction that exists between the uniformed military attorneys and those that met in groups that crafted the memos, going all the way back to John Yu's original memo, which I think was January 7th of 2002, and then there was an iteration over about 18 months, culminating in the DOD panel in March of 2003. I think it's true to say, as Schlesinger report points out, that those who practice this law, Geneva law, UCMJ law, for 25 or 30 years in uniform, their voice was not heard. Schlesinger's report clearly says that, and basically said that Rumsfeld, before he authorized certain extra coercive measures for use principally at Guantanamo Bay, there's no allegation that he intended them for use in Southwest Asia, but he did not heed the advice of either Alberto Moro, who was the General Counsel of the Navy, or more especially the military attorneys. Now, if truth be told, Chris, it goes back further than just the torture memos, because you go all the way back to the original military order that was part of the discussion of the first panel of November 13th of 2001, which sought to create a system for detention and prosecution of enemy combatants. That order, drafted very closely on the model from Roosevelt's order in the Kieran case. In the crafting of that, the military attorneys were just simply not consulted. That was drafted in the White House Counsel's office. And secondly, the decision of the President of the United States on the 7th of February of 2002, which bears into what Carlos was talking about, where, if I remember it correctly, the President of the United States, in drawing a compromise really between the DOJ-DOD position, which was the convention should not apply in Afghanistan because Afghanistan should be considered a failed state. That was the argument. And that was objected to by state, by Taft and by Powell in a memo, basically saying historically that's not correct. And so what the President did is a compromise. He said the conventions apply in Afghanistan, which is very important because then Common Article 3 applies. If the convention applies, Common Article 3 applies. But no member of al-Qaeda is protected under the convention simply, as Carlos said, because al-Qaeda is not a state. And more importantly, al-Qaeda, by its public acceptance of the horrific events of September 11th, in which it targeted innocent civilians, which is a clear violation of the law of war, basically denuded itself of any lawful designation as an enemy combatant under the Geneva Conventions. And as to the Taliban, no member of the Taliban could be considered under the protection of the Geneva Convention simply because they failed the fourfold test of Article 4 of the Geneva Convention on what's a combatant, which is the supervisory relationship, carrying your arms openly, wearing, actually the Geneva Convention speaks not in terms of a uniform, but a emblem which separates you from a civilian, and compliance with the rule of law. In the first panel, there was discussion about the Article 5 screening tribunals, and they should not be confused with the military commissions, but even Colin Powell argued that what we were doing in the initial stages of the war, as we had done in 1990 and 91 when I was still wearing the uniform, and what was to employ these procedures to at least give some semblance to the cry that we are complying with international law and what we're doing. We chose not to do that. The administration chose not to do it, and Colin Powell argued and lost in the White House on that very issue. But the whole concept of the relationship between the military attorney and the rest of those either political appointees in the Department of Defense or those in OLC is at best described as not in harmony. And the greatest concern of the military attorney is not so much the fact that they do not feel that the OLC determinations of sweeping presidential authority in the OLC memos are correct, and they were not able to debate that in the Pentagon group. They were prohibited from debating that. They worry more, and I totally agree with this, about the long-term precedent we've set by crafting ways to avoid the War Crimes Act, which is clearly the overriding theme of the memos, and what we do as far as the potential threat then posed by our own servicemen 5 or 10 years from now. I can conceive of a situation of one of our servicemen being kidnapped, held in some country, held against their will, and we come and we protest and we say that is a violation of international law. You can't do that. You must either treat them as prisoners of war in the Geneva Convention or release them. And the cry comes back and they said, well, you set the precedent in Guantanamo Bay. Or conversely, they employ some type of coercive measures that every member of the international community would construe as within the definition of torture, is generally recognized, and they would hold up our torture memos and say, you did not define it as such in those years. So the problem is, Neil, that the military attorneys, those wearing the uniforms, cannot stand here or sit here at this podium and tell you this, because they're still servants of the sovereign, and they do not speak out. But it needs to be said that there is a tremendous amount of friction and disagreement between those two groups that were brought together in this camp, particularly in March of 2003.
David?
Curious to the idea to open it up.
Mhm.
John, I'm curious whether you think, in fact, any nation we're likely to have been in conflict with was deterred from mistreating our soldiers that they were holding by virtue of the fact that we hadn't issued an OLC memorandum of the kind that we've now issued.
I think the question is better phrased in a broader context. I don't think we have ever claimed that we comply with international law or the Geneva Conventions because the other side does, or that we are compelled to do it because the other side does. I believe our public policy pronouncements and our official government position is that we comply with the Geneva Conventions because it is the right thing to do. And in effect, we are at least attempting to protect our own servicemen. McCain said this, I think, on the floor of the Senate, and I think he was exactly correct, that if in fact we are seen as deviating through official policy with these conventions that we have held aloft and touted as what we subscribe to as an American people, I think we start a slippery slope that I do believe puts our own servicemen in greater danger than they might have been even before. I'm not suggesting that in Vietnam or in Iraq in 2001 that our servicemen were not tortured. They clearly were. But we lose the bully pulpit when we start to reduce our level of compliance on the theory that the other side is not.
I have a question for Carlos. In thinking about international law, one thing I've been trying to figure out in my own mind is, putting aside the statutes for just a minute, do you have thoughts about the relationship between treaties like the Geneva Convention, Torture Convention, maybe the Law of Nations or customary international law, and the president's authority to act? And I was thinking in particular, just again, putting aside the statutes, I could see an argument that the president and maybe the courts won't be able to enforce this, but the president's really obligated in deciding how to exercise the commander-in-chief powers to follow certainly treaties, which you could say are part of his duty to execute, just like he has to execute statutes in the Constitution itself. But on the other hand, it also occurred to me that we know that one of the sort of sovereign powers the United States has is the power to decide at times not to be a follower of international law. And it'll have consequences, probably domestically and internationally, to do that. And we know Congress can do that. Congress has been confirmed to have the power to override international law if it decides that's necessary to do that. And I wonder if there's ever a time when the president gets to act as the sovereign for that purpose. And if there is a time, would it be something like the core of the commander-in-chief power, whatever that core is? I was thinking in particular of perhaps decisions about what weapons to use or something like that. Or do we say as a constitutional matter, no, the president just doesn't have that option to act as an agent of the United States with respect to our international law compliance, even if the court, we're not really talking about judicial review here, I think, but just as an abstract matter. Or is there some ability of the president to make decisions about international law?
Well, very good question. Let me talk about first customary international law and then treaties. with respect to customary international law, there is authority for the proposition that the president can countermand it, order a violation. Even the paquete habano, which generally is taken for the proposition that international law is part of our law, has an exception for controlling executive acts. And more recent cases, such as Garcia Mir, take the position that even cabinet-level officials can authorize a violation of customary international law.
Also, I think it was important that the dog owner should be able to.
Thanks, Scott. I have no idea what that was. The undisclosed location music comes in again.
So with respect to customary international law, I think there is authority that the president can, in certain circumstances, countermand it. I don't disagree with that. I think for the reason you mentioned, that customary international law evolves, and part of the way it evolves is through violations, suggests that someone in the country should have the power. And one could take the position that only Congress, plus the president through legislation, can do that. I think accepting the power of the president to do that in certain circumstances, well, I think the better rule is the president in certain circumstances can. The question is what circumstances, and one position is that in any circumstances, the president simply gets to countermand international law, is not bound by it. The position, I favor a more limited position, which is that if he has independent legislative power under the Constitution, such as with respect to, such as the Commander-in-Chief clause, or the power to recognize nations and accept ambassadors. If the president has independent, particularly strong powers under the Constitution, that's the circumstance in which he can countermand customary international law, although there is authority for the proposition that that the president can do so even more broadly. With respect to treaties, there I think the issue is more difficult. Clearly Congress, by enacting an inconsistent statute after the fact, can essentially terminate a treaty for purposes of domestic law. The question is, can the president alone do so? One sort of relevant line of authority is the cases and scholarship that discusses who can terminate a treaty. I mean, the one argument would be if the president can terminate a treaty, he, a fortiori, can violate it. And the memos, the OLC memos, I believe, adopt that position. I don't think that it follows. I think the fact that the president's power to terminate a treaty, assuming he has that power, could just give him the power to terminate it, but until he does publicly terminate it, it's plausible to take the position that he's bound. The treaty is, after all, the law of the land. Then there's the question of whether the president does in fact have the power to terminate treaties unilaterally. The Supreme Court in Goldwater versus Carter did not decide that he could. It dismissed the question as a political question, and a plurality dismissed it as a political question. And so, in theory, the question remains open. The one justice who addressed the issue was Justice Brennan, who found that in that case, the president had the power to terminate the treaty. But that particular treaty and the termination of the treaty was closely connected to the recognition of China. And so the argument, an argument similar to the one I made earlier about customary international law, might apply here, that the president can terminate a treaty pursuant to his extraordinary constitutional powers, such as the power to recognize foreign governments, but that he doesn't have a broader free-floating power to terminate treaties on his own without the consent of either Congress or 2/3 of the Senate.
I am a little bit more troubled because I can't as easily resolve it. The OLC memos basically have one overarching statement, and that is the President of the United States, when acting under his commander-in-chief power under Article 2, cannot be constrained by either Congress or international law, because what he is doing is akin to a battlefield tactical decision. Now, there is merit in that argument. The problem is, are decisions on interrogation techniques clearly akin to a tactical battlefield decision? I'm not sure they are. I don't think they are, but I think it's a novel argument that needs to be dealt with, because this whole concept of the war on terrorism is so totally different, a totally different paradigm than the classic traditional war, where the evolution of battlefield tactics evolved with some clarity. But if you're dealing with a war that knows no bounds, that knows no fixed end time, then whatever the president does in decision-making, whether it be directing that a Hamdi or a Padilla is an unlawful combatant and can be held by the military, or whether he approves coercive interrogation techniques, and there's no evidence that he has, but approves them because he determines that the need for that intelligence is paramount, then I think it's an argument that needs to be dealt with. But the question to me is not so much the authority of the president and the commander-in-chief, but is that tactic equivalent to a battlefield tactical decision? And I don't think we know the answer to that yet.
Add something. Even if one accepts the argument that I've described earlier, that the president does have the power to countermand a treaty obligation or customary international law obligation, I think that would simply get you to the conclusion that the president can order, say, conduct that violates the Convention Against Torture. But I think the memos go further and if I'm reading them correctly, take the position that the treaties cannot bind the president or even lower level executive officials who are essentially helping the president fulfill his power in the first place. In other words, I think the memos don't even require an express declaration by the president that he is countermanding a particular rule of international law, and I think that's going well further than the debate as I described it earlier.
Okay. Scott, I want to go back to the sort of initial dichotomy. Does it matter who's doing the questioning, right? Suppose we bring in a military contractor. Does that change the legal regime, or a CIA operative?
It changes it drastically, Neil. You lose the military code, the Uniform Code of Military Justice, again, which is the highest standard. So that when we're looking at this grid that Chris has got written out here, the most constraints apply when you're dealing with a uniformed member of our armed forces, wherever in the world, because the applicability of the standards are at their highest. The military contractor, DOD contractor, is not subject to the Uniform Code of Military Justice, nor is the CIA. Now, arguably, there are two provisions in the Uniform Code of Military Justice. One is Article 211, which deals with basically dependents accompanying the forces overseas. That was struck down by the Supreme Court in Reed versus Covert in 1957. And civilian contractors, again, were decided by the Supreme Court not to be subject to the Uniform Code of Military Justice in the case in 1960. That loophole was finally closed but 4 years ago in an act called the Military Extraterritorial Jurisdiction Act. And what it does is it finds jurisdictions, not in military courts martial, but in the federal courts, where you're dealing either with a DOD contractor or subcontractor, or a dependent accompanying the forces overseas, when the offense under federal law, if committed in the United States, would carry in excess of 1 year imprisonment. Not 1 year, but in excess. So that act, to my knowledge, still untested. I know of no trial that's been brought under MEJA. And the DOD, I think, was still trying to finish up the implementing regulations, because there was a very involved process involving military who would take custody of someone overseas for purposes of federal trial. That would arguably give you a constraint against the DOD contractor. a DoD contractor. And
And what standards would you be applying?
It's-
UCMJ standards?
no, you would not be applying UCMJ standards. You would basically be applying federal law, the body of federal criminal law, as it applies in this country. So you're dealing with, say, felonies, assaults, indecent assaults, similar to the Uniform Code of Military Justice, Chris, but under regular federal law rather than Uniform Code of Military Justice. Now, again, this has not been tried. Interestingly, it was originally intended to govern more military dependence overseas, because for a 40-year period, they were in a vacuum. If, in fact, they committed a crime in England, France, wherever, they could not be prosecuted by military court-martial by virtue of the Supreme Court's decisions. There was no federal court jurisdiction in this country, therefore they were basically subject to foreign host country jurisdiction, which went against our Department of Justice concept of maximizing jurisdiction. So the military, for this period, just ended up sending dependents home administratively. There was no judicial action. That was the purpose of the Military Extraterritorial Jurisdiction Act. Interestingly, this conflict in Iraq and in Afghanistan is employing more DoD contractors, to my knowledge, than any other armed conflict the United States has ever participated in. And as far as the interrogation function, further interest to me is there was a memo sent out by the Department, Assistant Secretary of the Army in 1999 saying that the interrogation function was so sensitive that it could never be contracted out. It always had to be dealt with by a uniformed military personnel, because the Army's manual basically says that use of force is not productive. Trickery is, use of force is not. Well, obviously there had to be a change of policy in the Army, because we know that CACI, Titan, other DoD contractors are heavily involved in the interrogation function. But the standard, Chris, is basically felony law. That's what we're talking about. When you move, of course, to CIA, CIA is not governed under either the Uniform Code of Military Justice or MEJA. MEJA does not cover them. And you only have two options that I can think of to deal with a CIA contractor, or CIA employee, or a CIA contractor like Pizarro over here in Raleigh. One is, if you can make an argument, one, that you're in an area where the Geneva Conventions nominally apply, and you're not in international armed conflict, but nonetheless Common Article 3 applies. And Common Article 3 precludes torture, cruel, inhumane treatment, or any, basically, abuse, coercion. Then, under the War Crimes Act, which, as Carlos pointed out, carries the death penalty if death results, you have jurisdiction in our federal courts. The only other way that I think you could reach a non-DoD civilian contractor or employee is through a very minor provision of the Patriot Act, USA Patriot Act, which enlarged, I think it's 18 U.S. Code Section 7, which defines what is the special maritime and territorial jurisdiction of the United States, and includes a portion that says basically, and I'm paraphrasing, when you're overseas, the areas that are used for exclusive American activities, including military activities, are folded into the definition of federal maritime, special maritime, and territorial jurisdiction. And that then allows you to bring the federal law into detention facilities that are operated solely by the United States during this period prior to the transfer of sovereignty. So you've got either the Patriot Act extension of 18 U.S. Code 7 or War Crimes Act, if you can find a violation of Common Article 3 that could possibly apply, dealing with that type of individual overseas.
Let me just add that the Convention Against Torture would apply to contractors. The negotiating history makes it absolutely clear that when it refers to persons acting under color of law, that it includes private parties on whom certain powers have been delegated, and in particular, it makes it clear that contractors are covered. And so presumably also the statute implementing the Convention Against Torture would cover them, and I think it would also cover CIA. There's no reason I can think of why it wouldn't cover the CIA.
Right. Although it applies to torture within the jurisdiction.
No, this is by U.S.
outside.
nationals.
Okay.
By U.S. nationals outside the jurisdiction of the
Outside
United
the
States.
jurisdiction.
Now, one thing that that is of interest to me, and I don't know the answer. But the argument is made with regard to prosecution in our federal courts under the War Crimes Act, that because the Office of Legal Counsel has determined that to satisfy the War Crimes Act, there has to be such a high standard of defining the offense that that would basically preclude, that determination by OLC will preclude any Department of Justice prosecution in this case, because the OLC guidance would be determined to be definitive as far as how you characterize the offense. And I don't know. I'll turn to somebody else. Chris, is that correct? Would that basically preclude any federal prosecution of, say, a CIA agent who is accused under the War Crimes Act?
I don't think so. I mean, perhaps as a matter of Department of Justice policy. I mean, as long as they have stated an official legal position that X behavior is not covered. But my understanding of the way the torture memos were constructed is they had very little participation by criminal who would normally want a place at the table when you were asking for an authoritative interpretation of a criminal statute. So I could see and of course now they've been withdrawn. What was the exact verb that was used? They are being
Reconsidered.
They've been asked to be reconsidered. They're under reconsideration. But I think it's within the Department of Justice's internal prerogatives to reconsider those positions.
But until they are reconsidered, I guess my question is the OLC document binding on criminal?
I don't think so. Randy, what do you think? I mean, you'd have to fight it out, right? You'd go to the Attorney General and you'd sit down and there'd be a battle between.
Anyways, I guess we're saying it's one thing to talk about these as possibilities, but
the government telling me this was legally permissible to do so, it would violate due process. And
Right, that may, yeah.
Well, and it might also go to mens rea.
Right.
It might also go to mens rea, the degree of whatever the wrongful state of mind you have to have. If you're defending someone with a memo like that out there as a defense lawyer,
Right.
you're going to argue that your client can't meet the standards of culpability, whether it's knowingness.
Right, it might defeat the prosecution.
Yeah.
But on the issue of whether a prosecution could be brought, I think as a matter of Department of Justice internal procedures, a prosecution could be brought.
Well, I think, I mean, my sense of it is that it, as a practical matter, what would happen is the decision whether to bring that prosecution or not would ultimately be bumped to the Attorney General, who would have the authority to overrule OLC in any event.
Yeah.
Yeah, I think the position of OLC would be, until the Attorney General does overrule OLC, that it is binding on the criminal division. But as a practical matter, what you described is right, it would be bumped up. But I can't imagine there could be, that could be applied retroactively.
Mike?
This is more of a question than a statement. Then what is the legal status of reconsideration? What's the legal significance of something being, the OLC opinion being reconsidered? Is it wiped out like a vacated opinion of a court or not? Because if it is wiped out, then you go back to the status quo prior to the memo. But I don't know the status of a reconsidered OLC.
I mean, what I would think, I mean, it certainly is not something that's happened with much frequency. As I sit here, I'm not sure I can think of. I mean, there's certainly been legal doctrines that have been evolved and changed over the years, and new administrations or new offices have taken different views on some issues. But it's not sort of the withdrawing of opinion is something I can't think of happening in another case. But I think it still comes down to what Victor was talking about mens rea and the sort of due process, and that if during the period of time between the time the opinion issued and the time which was withdrawn, or whatever words they used, someone relied upon that opinion, I think their defense lawyers would have some pretty good arguments.
It would certainly make a difference whether it was that action you just referred to was taken before or after the reconsideration.
Yeah, I mean, at this point in time, I think someone would be acting at their own peril to acting in accordance with that.
Because I think, to my knowledge, none of these memos have been rescinded. I think the only thing we determined was they are under consideration or review, but have not been rescinded.
But I think we can't avoid Don's point. lot of the low-level people were not aware of these memos. The question is whether, given that it was the government's stated position during the time of the conduct of which they're charged, that it was not lawful, is the government held to that, even if subsequently the memo was rescinded? And I would think that it would be, at least my understanding of OLC's role in articulating legal standards for the executive, would be that the criminal division would be bound by that, even absent reliance on the part of the criminal defendant.
Could I just ask Nina to clarify? But not because you think the Constitution would require, right? I mean, the due process clause is going to start ringing when you can make out actual reliance.
Right. Right. Not
You're
as
talking
a
about
constitutional matter, but as a
departmental
matter of
policy.
what the executive branch thinks it's doing. In
Right.
terms of, and so, yeah, it's
Right.
totally internal to the executive branch. So constitutionally abandon that and go on to a different model of legal advising. But that's
On the other hand,
implicates a lot of institutional.
On the other hand, one might not want to sort of undersell the kind of reliance argument you could make. If you thought you were actually pursuing some authority, you wouldn't necessarily have to think it was the OLC opinion that was giving you the authority, right? If you just thought that it was part of your job to be doing that.
Right, and it's transmuted to the line person
Right.
through statements of people, don't worry about that, we're under a special access program here.
Right, and I think from from the Office of Legal Counsel's perspective, the sort of reliance and due process point is an important point and a good point because it's one of the motivating factors for people to pick up the phone and call OLC and actually ask for legal advice on these issues, because people believe that if they're in an area which is a risky area, if they have that advice, that it provides them with some protection, and they can go out and act and not worry about the legal consequences of their action because OLC has told them that it's permissible.
Yeah.
Sarah?
Well, I don't even think if you actually had a prosecution, you had somebody that was relying on it, I don't think you'd probably have to get to the due process level, because there's that line of cases about entrapment by estoppel. And if you had an opinion telling you could go ahead and do something, I think in the lower federal courts there's it's a small number of cases, but I think you'd go there maybe as well as a backup due process argument.
So let me go back to rephrase the question I asked Scott a while back, just on this point of entrapment by estoppel. Is the argument different for a person in the armed services than it would be for a CIA agent? Because in the armed services, you've still got the UCMJ rules and regulations, to which the memos don't speak directly. They are not analyses of the operative constraints on people in uniform. This looks much more like an effort to give an immunity bath to military contractors, perhaps, and CIA agents operating at the vice president's undisclosed location.
No, I think you're exactly correct, Chris. And it is this point that created the great friction between the military attorneys and the rest of those in the working group, because the military attorneys said, we are held to a standard of the Uniform Code of Military Justice, and therefore we need to engage in a conversation about the OLC memos, but they were precluded from doing that by the chair of the committee, who said, what we've been talking about, the OLC determination is dispositive of the issue. And I think there is a difference between those in the uniform who are subject to a totally separate code, the Uniform Code of Military Justice, with its own punitive provisions, and consideration of CIA and DoD contractors either under MEJA or under War Crimes Act or under the extension of Patriot.
Unless this muscular theory of executive authority, the commander-in-chief power, is right. And I guess it would have to be muscular on steroids, because it would have to be the kind of argument that once the president says you can do it, and he's using his commander-in-chief authority, you can do it notwithstanding any other provisions of law, rules and regulations. When I worked on Capitol Hill, I once ran into a staffer who had been around for a long time, and we were working on a piece of legislation that had this language in it, notwithstanding any other provision of law. And I asked him, what is that in there for? He says, well, because we don't know. We don't know what's out there. we don't know what effect this language is going to have. We just want to make sure we've got an argument that this statute is, overrides whatever it could be. So it's not as if people had analyzed the ramifications of that provision. They were trying to create a kind of legal black hole. And I guess for the part of the torture opinion that rests ultimate, push comes to final shove kind of authority on the commander-in-chief power, to get over the UCMJ problem, you'd have to read it that way. No clear statement would be required by the president. He wouldn't have to say, and I mean the UCMJ. He'd just have to say, do it, and that would provide full legal authorization for anybody operating under that instruction. That seems kind of majestic in its scope.
When Carlos was talking about Piketty Habana and Garcia Mir, which does extend the shield for domestic prosecution based on an executive order, the torture memos had an interesting statement in one of them. It said, if you're in fact going to employ the presidential authority at a lower level, there should be some memo somewhere that signifies that presidential authority. And of course, that's what set the press on fire looking for this smoking gun as far as President Bush. I don't think one exists. Clearly, it exists at the Secretary of Defense level. But if in fact you say the President of the United States, as Commander-in-Chief, specifically authorizes the military to breach the Uniform Code of Military Justice, I think you've got a whopping big separation of powers issue there because of the code and the congressional legislation.
Peter?
I'm sorry. Just add, as I read the memos, it doesn't even require a specific directive that
At least
you
the
can do
DOJ
it.
memo does.
DOJ.
Yeah.
Right, the DOJ memo says it would be useful, it would be helpful, but it's not necessary.
Yeah.
Peter?
That's a factual question. We're talking about DOJ memos primarily. There are also these DOD memos that would be classified that listed interrogation techniques that, that at least for some period of time were asserted to be permissible on a general use basis, at least in Guantanamo, including, as I recall, physical contact of a kind that had never been committed before between military personnel holding people in custody in their prisons and some other kind, a couple of techniques that were flagged as our allies may consider this torture, but you can do it anyway. And I'm interested in the authority for that, and I guess I'm also interested in the end, what I wound up thinking after reading it was, oh wait, this is, what they're actually imposing here is more restrictive. It's a rule for Guantanamo that's more restrictive than whatever they're doing in, and we don't know yet. You guys are talking about undisclosed locations. I gather what we're talking about are maybe Diego Garcia, maybe inside these container, shipping containers that are being used as prisons that we've heard about outside Kandahar. And I've also heard reference to ships at sea, where people are being held and interrogated by what they're calling other government agencies, but what I assume is the CIA. And I guess my question is there any sense of restriction of any kind? I mean, the government has clearly been looking for a law-free zone. And my question is, first in part about this DOD memo in Guantanamo and how far that goes and on what authority. And then, have they found a law-free zone somewhere?
The DOD memo that came out in April of 2003, when you read it, basically incorporates the entirety of the OLC doctrine. I mean, it is. When that memo for the first 40 pages is virtually identical to the one that came out of John Yoo in January of 2002. Then you get the iteration of the UCMJ offenses and defenses that could be raised, notably self-defense, which is the theory that if in fact we are in war on terror, that whatever tactic you use in this war is in the nature of self-defense because the country is at war. I'm not sure I agree with that, but that's basically what was posited. But again, there are two aspects of that. One, Rumsfeld authorized certain extra legal, if you want to put it that way, measures for Guantanamo Bay only. Then Alberto Moro, who was the General Counsel of the Navy, went directly to Jim Haynes, DOD General Counsel, and says, we just can't do this because there are codal provisions. You can't do that. Then that prompted the DOD working group that met in March of 2003, and Rumsfeld had rescinded those at that time. But the problem was those techniques that had to be approved by DOD SecDef then were in the possession of General Miller when he went on his mission to increase productivity of intelligence gathering in Southwest Asia. And I think it's now not even debated that what happened was that the culture changed in Southwest Asia, where the Geneva Conventions clearly applied, whereas at Guantanamo Bay, the government's argument was the conventions did not apply to anyone down there. So I think that's factually what happened. But it was the military lawyers and Alberto Moro, who stood shoulder to shoulder with him, that caused the rescission of the first DOD set of rules and the evolution of the second set.
One thing that's very striking about the DOD memo is Scott is right that the legal analysis of what the 2340 requires or permits and what the Convention Against Torture requires and permits is taken almost directly out of the DOJ memo. But when you get to the particular interrogation techniques that were authorized or not authorized or authorized under certain limited circumstances, there's a significant gap between what is permitted under the DOJ's interpretation of these instruments and what was authorized. Under Category 3, which is the one that's to be used with the most restrictions, authorizes some contact, some physical contact, but not extreme contact. The DOJ memo says it's not torture unless it rises to the level, serious, it causes permanent and serious physical damage rising to the level of death, organ failure, or the permanent impairment of a significant bodily function. And specifically, as an example, says that kicking someone in the stomach with an army boot while he's doubled over is not torture and is permitted. And even if it were, the president could authorize it. So there seemed to be a significant gap between what the DOJ memos found to be permissible and ultimately where the disagreement and the disagreement lay as to the particular interrogation techniques. Category 3, use of mild, non-injurious physical contact is the most coercive mechanism that was under certain circumstances and under certain conditions authorized.
But was rescinded after the military working group of 2003. So you have, in effect, it's widely available. You have a list of those things that Rumsfeld approved for Guantanamo Bay prior to the working group, then you have a list, second one. And in this, I think you really see the influence of some of the military attorneys whose voices at least were considered that moderated these things and tried to get them as close to existing international law as we could. But then where they couldn't do that, then they built a regime of defense that was in many ways similar to what DOJ had done with regard to Defense Against War Crimes Act. But if you talk to some of the military attorneys who would prosecute, they say they really wouldn't work.
Vicki?
This may take us off to another topic, so it's fine if you want to rule it out. But listening to the panel, I am just struck by the apparent disconnect between the processes by which the executive branch formulated its approach to the law and the distribution of those who within the executive part of the government had the incentives to care about all the features of it. So cutting the military lawyers out of the higher levels of legal decision making, in a sense, deprived the executive branch of the benefit of those who, in a sense, had the most interest in getting it right as a matter of international law, because their folks would be subject to the regime that would be influenced by our interpretation. Okay, so there's that piece. But then you say, well, why were they cut out? And part of the reason they were able to be cut out, I take it, is because of the principle of civilian control. And so if the civilian lawyers say, no, you're out, then I gather that, I mean, I'm sort of asking about how it happened, because the principle of civilian control is on the whole, we think, a benign and good structural constitutional thing. So it seems to me there's a problem with two kinds of ways of looking at this, colliding with each other. So I guess there might be a factual question under this, which is how often on other important issues of law have military lawyers, uniformed lawyers, disagreed with their civilian supervisors, and how has that been handled in the past? And as I said, this is not exactly about international law. It's more about the process, so it might be better for another panel, but it was raised by your comments.
It's a very accurate assessment that there is friction. It tends to be more issue-driven within what's called the Judge Advocates General, the senior attorneys for the different services. and the service general counsels who are political appointees. Again, I thought it was tremendously significant that the Schlesinger investigative report and I think it's the only time it's ever been identified, specifically commented on your point, that the President and the Secretary of Defense were deprived of expert advice that they could have gotten had the military attorney's voice been heard. There is a bill in Congress, I think it's an amendment to the DoD Authorization Act, that would elevate the grade of Judge Advocates General, who are now 2-star generals, to 3 stars. I don't really think it's going to do anything. The question is not so much the classic constitutional issue of civilian control of the military, it's the fact that nobody asked these people, going all the way back to the initial days after 9/11. The decisions being made were being made in DOJ and White House counsel and at the highest levels of DOD, but even Rumsfeld and company were not that heavily involved in the initial crafting of the strategy. You saw this in the decisions on prosecutions. Why was a John Walker Lynn thrown into federal court? Why was a Moussaoui? Why were others thrown into military commissions? There was no integrated strategy that was built to handle with these cases, and they were dealt with anecdotally as they came through the system.
Adam? I was wondering if you could talk about the restrictions, if any, that apply to rendition of detainees to third countries and for further interrogation.
Who's the questioner? Are we talking about CIA? Again, because if you're talking military interrogator, it doesn't matter where you are. The Uniform Code of Military Justice is not based on any territory.
I think Adam's talking about turning him over to, say,
No,
Egypt.
Oh, rendition?
A third country.
Rendition?
Rendition to a third country.
Yeah.
That's clearly violative of torture convention. I mean, it's not that we can't do it, we can't render them. Now, the torture memos suggest that we are interpreting that as saying we are prohibited from doing that only if we are certain, not that they might be tortured, but that they will be tortured. And that gives you a lot more leeway to do that. But again, that's the OLC determination of how that applies.
The Convention Against Torture flatly prohibits deporting someone to a place where he would be tortured. I'm not certain of the language used in the convention itself. The United States took a reservation which says that we interpret that to apply only if it's more likely than not that he would be tortured.
Yeah, Dawn?
I just have a factual question. I haven't read the Schlesinger report and wonder, do we know from there anywhere else whether OLC in fact did involve DOD, state, criminal division, other parts of the government in invite advice before issuing the torture memo?
I do know that the military attorneys were not brought in until March of 2003.
Okay.
I don't know the answer.
I'd like to raise the issue of remedies. It's fairly clear what kinds of remedies are available under the UCMJ. But when we're outside that statutory regime, when we're operating under especially the international law, okay, there's a violation, right? Assume a violation. What happens?
Well, we've been discussing criminal prosecution and the extent to which the OLC memos are themselves a barrier to prosecution. Of course, they're not a barrier to the extent that the standard in those memos has been violated. Court-martial under the UCMJ or other military remedies, I'll leave for Scott. One issue that I just wanted to raise is the possibility of a claim under the Alien Tort Statute after the Sosa decision. The court in Sosa did cite Filartiga seemingly favorably for the proposition that torture is considered an established violation of customary international law. So I think there is substantial support that if it constitutes torture, this would be a claim that could be brought under the Alien Tort Statute. A series of issues, though, may arise. The Garcia-Mira issue I mentioned earlier, if the President or the Secretary of Defense has approved it, that might be a ground for dismissing a suit brought against a U.S. official for violation of this customary international law norm. But I'll note that the president has not approved, has stated that they are to be treated humanely, the detainees are to be treated humanely, and hasn't explicitly approved torture. Conceivably, a qualified immunity defense similar to what applies in Section 1983 actions might apply, and so if so, that might raise the question of whether this violates clearly established law. And here, the OLC memos may be relevant as well in muddying the waters as to what is a violation of international law. SOSA may leave open the possibility of a national security exception. The court indicated that the courts were to determine whether there's a private cause of action for violation of particular customary international law norms. And I think primarily the factor to be taken into account is how well established it is. But presumably the court also contemplated, or perhaps it also contemplated, that questions of national security should be taken into account in determining whether to hold particular categories of defendants to this cause of action. Another question is how relevant is it that these prohibitions are memorialized in treaties that were declared not to be self-executing? The court in SOSA found the International Covenant on Civil and Political Rights not relevant because it had been declared not to be self-executing. The way I read the opinion, I think the better reading of the opinion is that if you can independently establish that it's a violation of customary international law, that it doesn't matter whether it's also incorporated in a non-self-executing treaty. In other words, I don't think that when you take a well-established principle of customary international law and then decide to incorporate it into a treaty but declare the treaty to be non-self-executing, you render that norm non-enforceable. I think that seems to it seems perverse, given that if we hadn't even incorporated it into a treaty, it, by hypothesis, would be enforceable under the Alien Tort Statute. But this is an issue that I think would have to be examined if a claim were brought under ATCA.
One thing, and we could have a whole conference on this, but in the background as a specter is this whole concept of the ICC. If you're dealing with an international sanction, then at least there is the concern of a possible attempt by the court to bring charges. And of course that would trigger the American Servicemen's Protection Act, it would trigger a lot of things, but at least I think there should be some concern, particularly after Abu Ghraib, when the United States pulled its proposed resolution from the United Nations Security Council, which on a year-to-year basis had requested the court to defer. We have not done that anymore because of Abu Ghraib. So I think we need to be at least technically concerned about a possibility of the independent prosecutor trying to bring some type of action in the ICC.
Let me draw this panel to a close by asking you all to join me in giving a round of applause to the panelists and thanking you very much. We're going to stand adjourned for an hour. We're going to reconvene back in this room after lunch. The two panels this afternoon are speak to some issues of executive power and the role of lawyers, but at a more general level than the more detailed legal questions we've been looking at this morning. So the first panel is on the powers of the executive, and we'll delve into some of these arguments that were made in briefs that were filed this term, but which the court never had the occasion to confront in a frontal manner. And then we'll conclude this afternoon second panel on the role of government lawyers in advice giving in these kind of circumstances. Lunch is available for all the panelists, who number about 20. We're set up for lunch for about 40. So other people who are in the room who want to continue a conversation are welcome to join us. And it's in the Birdman Lounge, which is on the 4th floor at the far end of this building. Third floor. Birdman Lounge is on the 3rd floor at the other end of this building. I'm glad you've been here a while, Neil. You're on the 3rd floor. You're on the right floor.
sir.
cut off all the questions about who decided what.
No, I just, I had a
About
point
the
about
executive
the,
power.
What is war or not, and what is conducting hostile operations or not, and is.
You mean traditional war versus
No,
military?
no, the one that you made in terms of torture, is that a conducting?
Battlefield tactics.
But you did the alternate, but in terms of battlefield, so I
you mentioned it's torture.
broad
Because some of the aspects.
Let me give you Congress decided to ban the use of napalm. Would that be constitutional under the way you're looking at it?
Well,
Assuming, I don't know if that
well,
made